Friends, we are starting now. Today is our 201 Friday group meeting. The speaker is our beloved Dr. Karnika Seth. The topic is combating deepfakes and cybercrimes. Karnika ji earlier also addressed our Friday group, that is on 3rd May 2019, Law of Data Protection and Privacy in India, and 2nd September 2022, Intermediary Liability on Internet. So I request Akanksha kindly read Madam's few details.
Dr. Seth is an internationally renowned cyber law expert practicing in the Supreme Court and High Court of Delhi since 23 years. She acts as a legal advisor to the Ministry of IT and Defence Ministry, Government of India, and actively contributes her expertise in various national projects. She is the appointed country chair, AI and cybersecurity for G100, a global group of women thought leaders, and drafted a proposed AI law for India. She is a accomplished arbitrator, author, policy expert, and is a visiting faculty to the National Judicial and Policies Academies. She is the highly inspiring speaker on emerging tech in industry conferences, print and electronic media, and television. Dr. Seth is the founder of the Seth Associates, an established law firm based in Delhi that renders legal services to both domestic and global clients. We welcome you, ma'am. Thank you very much for your humble invitation.
Karnika ji, please initiate. Correct.
It's indeed a privilege again to speak at this Friday group forum of lawyers, and we're talking about new tech today. It's a 201st meeting, which is of the Friday group after the 200th celebration, which was a wonderful achievement in the history of Friday group. And it's an honor to take the 201st session today on the very interesting and a very informative topic, which is the deep fakes and how cybercrime is emerging with deep fakes, and what in India and abroad the initiatives which are being taken to combat this problem. So we are essentially focused on this issue today. When we say deep fakes, today's lecture is basically going to be an overview of what this technology is in the first place, and how this technology is proving to be a havoc, and an epidemic in the cyberspace, and how the deep fakes, what are the current provisions rather, which would apply to a crime like this, and those sections or provisions of law which are in the offing. Maybe some things are under the radar, some things like some acts which are still in the pipeline, and how the world, for example, other countries like US or Europe are tackling with this problem. While we are discussing the same, we'll also touch on a few cases, very few landmark cases, which are like milestones in this whole journey of combating deepfakes. So I start by a clip. You must have seen this in the news very lately of Rashmika Mandana's case, and it's so easy to manipulate figures or faces or facial expressions today. Just a very fine work of technology, morphing we call it. So when a face is superimposed by images and an alteration occurs in such a way that it looks as if another person is on the photograph, you just manipulated the whole photograph and becomes forged, and that's what is a creation of a deep fake. I just wanted to have a visual reference before we actually delve into the literary aspect of it. But then when we saying deep fakes, it is emerging out of deep learning. Now when we talk about artificial intelligence today, AI has become an everyday facet for us. Whether it is Siri or Alexa, or the social media platforms are already leveraging AI in the tech space. How deep learning, that is machine learning, is creating this phenomena that one can actually create a deep fake. On the social media, you would have come across so many instances. For example, if you see even there have been Bollywood actors, celebrities who have been, whose identity has been stolen. There have been various instances where even videos have been morphed. So whether it is politicians or it is Bollywood or celebrities, I mean, it's some public figure, usually who is a target of this crime. Obvious reasons, because it's either it will be a financial crime or it will be a damage which is intended to the reputation of a person. And there will be several instances where you would have seen that this is leading to misinformation and disinformation. So whereas disinformation is a targeted intentional act, so that there is a election, for example, happening, and that has to be manipulated. So the public voting and the image of a particular party has to be managed in the eyes of persons. Then disinformation flows using deepfake technology. Likewise, it could also be for other cyber crimes like extortion, for instance. It could be for defamation, intended at defamation. It could be intended to amalgamate with other crimes like cyber pornography, for instance, or even sextortion, for instance. So the ramifications, the ingredients will depend on every case-to-case basis. So whether it is intended to make a monetary gain, for example, in the consumer protection area, if you look at how merchandise is spread. So there have been cases of those also, which we'll delve into, where the hoardings will have maybe images of celebrities which have been copied and altered, and those images have been put on, say, emojis or on t-shirts or other kind of merchandise to not only have a passing off, for instance, but also make monetary gains out of it. So there have been definitely a wide range of application of deepfake technology. My whole focus right now, to give you an overview here, is that this whole deepfake is not just targeted or is attributable to a particular kind of cases. So it is creation of photographs which are fake or altered or morphed, but could be used in many ways and for many motives and purposes and lead to various consequences. So depending on the facts of every case, that particular relevant law would apply. For example, if it is copyright law also gets applied. If it is only to do with defamation, then obviously defamation law applies. So in that spirit, we are understanding this. Before we even go ahead, when we say deep learning, so when a particular sample is given to an AI-based machine and it is fed over that training again and again and again, it leads to deep learning, and it starts automatically learning from the data analysis it is making. That is what is AI and deep learning. And with that comes the generative adversarial network, GAN we call it. Now that is the foundation also of the deep learning technology, which is creating deep fakes. So with that, what is happening, the creator of that particular software, for instance, or technology is actually responsible for creating it responsibly, and then its deployment has also to be responsible. That has become the agenda also of most countries who are, for example, the G20, who have given the discipline of responsible use of AI. So in that light, deep learning and deep fakes have to be also looked into from the ethical and non-ethical considerations. And it becomes the duty of the creator as well as the deployer of the same to ensure it is not used for any criminal activity. Also linked with that is a facial recognition technology today. So that is another aspect. While it has ethical use, for example, you recognize faces of people on airports. The law enforcement can legally use it also to create and detect cyber criminals, or to investigate crime. That is a correct use of technology. However, when it is used unethically for illegal motives, obviously it becomes cyber crime. With that background, I just want to also share with you that if you look at the global statistics, they are close to more than 1,000% increase in deepfake technology today. And the most affected is Spain. Whereas in Europe, in Middle East, in US, for example, there have been other countries also grappling with this problem. And more than 1,000% increase in the deepfake technology. In one of the local surveys which was done in India, most of the users who used technology today and were using social media found more than 30% of the videos which they saw were fake. So looking at the statistics itself makes it a important area to not only legislators but also the law enforcement bodies, and it's equally important for the legal fraternity to understand. That's why they lecture today. Just two examples I want to give you from the recent cases, just to highlight the importance and how we are understanding that this situation would cover which law would be applicable to that. In the Anil Kapoor versus Simply Life India and Others case, I'll repeat, Anil Kapoor versus Simply Life India and Others case, there was this Bollywood actor, celebrity definitely, and then what was found was that AI generated deep fakes were created, and his morphed pictures and images were taken and put on derogatory materials, including some obscene content. So with that, obviously the implication is that the celebrity will be defamed. And when this legal action was brought in the courts, it was held that his actor's personality rights have been infringed. His publicity rights have also been infringed. Now, when there is a likeness, there is a voice, there's an image, it becomes ingrained in a person. It is an inherent attribute of a person. Now, if that gets infringed, obviously the personality right gets infringed, and his right to privacy also in a way. So we have the very famous case of the Justice K.S. Puttaswamy case, wherein right to privacy is anyways been held to be a fundamental right of the Constitution of India. Now, when we saying personal attributes, now those cannot be misused. Obviously, whenever it's AI-based tools which are being used to create these deep fakes, and in such a scenario, when the court viewed that yes, his publicity rights or his personality rights have been infringed, prima facie material was there, and an interim injunction order was issued by the courts to restrain the use of such material. In another case, Amitabh Bachchan versus Rajat Negi and others. This is 2022 SCC Online Delhi 4110. Now similar deepfakes were created, and it was being used to make commercial products. So obviously when such a scenario happens, then the personality rights of the person, celebrity, are infringed again, and his personal attributes like voice, name, image, likeness again were basically being used to make illegal gains, commercial use. Now this is causing a loss to the celebrity as well, because it is his choice ultimately whether it has to have a consent. Without a consent, you cannot evade somebody's privacy and his personality right. After all, it's a brand. So therefore, the court again held that this was an infringement of the personality right of the celebrity and granted injunction orders in favor of the public figure. Right? Now, likewise, there have been many other cases like Manoj Tiwari deepfake video. You would have again heard of the same, when the BJP leader Manoj Tiwari was, the videos created with deepfake technology was circulated on social media, and this was, basically to put him in a poor light, where he was allegedly making some political remarks against his opponent Arvind Kejriwal. So these are very, very ordinary, I would say everyday scenario nowadays. So it's not something new. And in these two cases I was just mentioning, the Amitabh Bachchan case, for instance, a very important judgment was cited, which was the Titan Industries Limited versus Ram Kumar Jewellers. In this case, when the actor has signed, say, project with a particular jeweler for the advertisements and hoardings of that jeweler, no one else has a right to take away that image from that hoarding and use it for publicizing their own jewelry shop. That was also, looked into, and therefore it's a commercial contract, after all, which they have signed, and the owner of that copyright then is it's written in the agreement, will be the shop owner. So if that is the case, obviously, as per section 17B of the Copyright Act, they cannot violate this ownership rights and take away from the hoardings those images and transpose them into their own shops advertisements without permission, without consent, and infringing personality rights also of the celebrity. So likewise, there have been many other instances, but the key judgments which we've seen very popular cases highlight on this account. And interestingly, one more aspect was studied, analyzed in the Anil Kapoor case, was that many times this personality or publicity right is not standalone. It intermingles with copyright and also common law rights, like of an individual, of a public figure. So all three were examined in this particular case. And there were various false endorsements of Anil Kapoor as a motivational speaker. Somebody said that he is going to be a motivational speaker and would highlight a particular brand, which was a false news. And there were also seen dark patterns. Now I want to emphasize what this word means. In consumer law, when an advertisement is made giving a false, misleading proposition, like a particular, for example, affiliation with a celebrity or an endorsement by a celebrity, it becomes fake, and therefore that's known as a dark pattern. In India, consumer law, as well as in some foreign countries, it has been prohibited. This kind of and it has been said that there have been guidelines even in the Indian consumer law that there cannot be such an unfair trade practice, and use of deepfakes for consumer activities also is something illegal. So here that was also looked into. So name and images of this plaintiff were being passed off, and pictures of the same person were being morphed using deepfakes, and merchandise was being sold, magnets, t-shirts, cups, and so on and so forth, stickers as well, and many autographed photographs of the celebrity were also being replicated. So obviously, those are considered an infringement of one's rights of publicity. And many, apart from that, many domain names were also created. For example, anilkapoor.com. Now that's again something which is unethical. Without consent of a person, you're stealing identity of a person. So that was considered an infringing activity. And with that, there were many cited cases therein. But it was very, very clearly said that such an activity is a clear violation of even the settled law which was laid down in R. Rajagopala versus State of Tamil Nadu case, a very famous case. There it was very clearly held by the Honorable Supreme Court that the first aspect of this right must be said to have been violated where, for example, a person's name or likeness is used without his consent for advertising or non-advertising purposes, or for that matter his life story is written, whether laudatory or otherwise, and is published without his consent or explained thereafter. I'm just reading the lines from the judgment. So it's important to understand that Article 21 doesn't only say right to be let alone. It also is something which transgresses that and entitles one to a right to safeguard one's privacy. And not only that, privacy of his family or some personal information related to him or her, and whether it's truthful or otherwise. So without consent, unless it is a public record, that's a rider. Unless it's a public record coming from a public record, anyone can write. But if it is not so, then it is transgressing one's right to privacy, and that can be very clearly held to be illegal. Now, therefore, when a matter becomes a public record, one's right to privacy no longer subsists. That was the reasoning of the Honorable Supreme Court of India also in that Rajagopala judgment. So from that spirit, this was examined, and it was held that in such a scenario, once it's prima facie, I would say the rights of celebrity have been transgressed or infringed, it becomes a subject matter very clear that they could entitle injunction orders being passed. So these cases are pending at the moment. Going forward, I just also wanted to now come down to the laws which are applicable. Obviously, the special law in this case we are talking about is the Information Technology Act of 2000. Now, in this act, we have some key sections which could apply in such a scenario. For example, if identity is stolen of someone, section 66C is the applicable section. And there the punishment is up to 3 years and up to 5 lakh of fine. Section 66D, cheating by personation. Again, section 66D has the same punishments as in section 66C, 3 years and up to 5 lakh of rupees fine. 66E talks about violation of privacy. There, 3 years of punishment, fine up to 2 lakh of rupees. 66F is important because it is a punishment for cyber terrorism, and the deepfake technology is one weapon of cyber warfare today. It is actually a way of sedition also. It could be a terrorist attack as well. So keeping that in mind, the punishments are up to life imprisonment. Then when we see section 67A and 67B of the IT Act, section 67 is for punishment for publishing or transmission of any obscene material. Now, if that happens, again, the punishment is up to 3 years and fine up to 5 lakh of rupees. Section 67A of the IT Act punishes whenever there is a publication or a transmission of sexually explicit material. In that scenario, the conviction is up to 5 years of imprisonment, fine up to 10 lakh. Section 67B, which prohibits child pornography, even browsing, seeking, downloading or transmitting or publishing of the child pornography is an offense. Even grooming, child grooming. So up to 5 years of imprisonment and fine or more. Obviously in cases of subsequent convictions, there are higher fines and penalties or punishments. Now these are just a snapshot of what happens in the IT Act. We also have other provisions of law like the general law of IPC, where in various sections could be of importance when we're dealing with deepfake technology. When we say cheating, up to 1 year of imprisonment. Cheating by personation, cheating with knowledge is up to 3 years of punishment. Then forgery, right? Forgery, 2 years of punishment. And when we say forgery for cheating, 7 years of punishment. Forgery for harming somebody's reputation, 3 years of punishment and fine. Defamation, 2 years of punishment and fine. And various sections apply, of course. When we say forgery, 465, section 465 talks about forgery. 420 is obviously cheating. And when we say defamation, 500, section 500 is defamation. And forgery for harming the reputation of a person is 469. So here punishment is up to 3 years of punishment and fine. Now, I was actually just analyzing what happens, with the changed law, Bharatiya Nyaya Second Sanhita to 2023, a new law which we have now. So, most of the sections which I just mentioned, for example, cheating with knowledge, have increased fines or increased term of punishment there. Whereas IPC would for punishment of cheating is 1 year. Just an example, giving you an example, in the Bharat Nyaya Sanhita Act, it's 3 years. Cheating with knowledge, up to 5 years instead of 3 years. Cheating by personation, again, up to 5 years instead of the earlier 3 years. So there is an increase in the term of punishment. For forgery, it remains the same 2 years, and for defamation, again, it remains same 2 years. So that's just a contrast for the same. And apart from the IPC provisions, where general law of IPC, we have some guidelines on the prevention and regulation of dark patterns of 2023. I was just mentioning the consumer law, wherein one of the ways in which which is banned is the use of the deepfake technology to mislead consumers in any way. So if any photograph is morphed and has been unauthorizedly used without consent, obviously it is a misleading ad, and therefore it would also fall under that area of law. Ministry of IT has passed an advisory, also to tackle deepfake technology. And previously, Ministry of Home Affairs, I've in fact worked on the same, and that also is to deal with deepfake technology and fake news, how fake news is spread and how it can be controlled. The Ministry of Home Affairs also has done some advisories on the same. But one of the very important rules I would like to mention are the Ministry of IT rules of the intermediary guidelines rules. Now there, it is a very clear obligation for social media platforms to remove a deepfake content out or any illegal morphed content out within 36 hours of its uploading. So that's a very clear-cut guideline, and not only a guideline which you can't, it's not like soft code, but something which is enforceable by law. So you can actually do that. Now this brings me to the question, where do we report this? You have the law, there is a deepfake technology in play, you come to know these sections provide us protection. What do we do if this happens? Obviously we need to report it at the first instance, like we have an FIR. So a zero FIR concept is possible on the National Cybercrime Reporting Portal, which is cybercrime.gov.in. You don't even need to reveal who you are. It can also register complaints anonymously. So that's an interesting aspect of it. And the national helpline for the same is 1930. 1930. So that's also something which was of importance to mention here. And apart from these sections which I've mentioned, if it is deepfake technology is used to commit, say, or bring about disturbance in the community, religious sentiments of people are hurt or otherwise, then section 153A of the IPC also comes into play. 292 would be for obscene books and all, doesn't apply, but here 153B also would apply in such a scenario. So 3 years of punishment and fine in that kind of a scenario where there is a religious outrage, some sort of a sentiment of people being hurt. So with this, if we understand the ramifications, where we stand today, we do need a deepfake law in the country. We don't have a section clearly saying deepfakes are prohibited or banned. However, there would be certain ingredients, or those sections which I said would satisfy the ingredients of the existing law. But the new DIA Act, which is in the pipeline, the Digital India Act, it is intended to not only supersede, totally change the dimensions of IT law in India by overriding the provisions, in fact changing the law itself, IT Act, but also has a clear-cut provision on the deepfake technology. And high-risk systems which are AI-based systems, it seeks to regulate those and ban those. So that's something that the Honorable Minister G.Seshagiri mentioned in one of the roundtables. And again, we've seen those presentations, and it very clearly has those explicit provisions to deal with that. But so far so good right now. If we see the position in the world, coming to the world where we stand today, EU AI Act has very clear provision to say, and I'll specifically mention the provision as Article 52(3) of the EU AI Act, which says that if you have used a particular deepfake technology to create a particular work of art or anything that is a content, you have to watermark it. You have to mention this was created by deepfake technology. We've seen cases and instances reported in the press and media that in one of the AI technology use cases, a patent was created, and that was rejected because it was created by using by AI, generative AI. So we are looking at not only criminal side of the law, but also looking at how it is changing the dimensions of our IPR law itself. So a patent would not be granted, for example, in the US, if it's not been by a human being. So you have to have a human element to it. Likewise, in EU as well, they say that you have to clearly say whether this is made, for example, if it's a painting. In one of the cases I've read in the papers, a painting was created by AI, won the competition as well, and later it was found out that it was generated by using AI. So there needs to be a declaration, there needs to be a clear-cut, explicit watermarking to say so. And how else do we ensure its ethical use in financial markets, in NFTs and otherwise, in crypto segment? Use of blockchain will do that. Now one has to have blockchain like a ledger maintained of who is the owner of which asset, IP asset. That needs to be done. So watermarking will help the disclosure of whether whose IP asset it is. Blockchain will help, and also takedown of the illegal content. Whichever is illegal needs to be blocked within 36 hours. So those are certain combating, I would say, strategies which are currently helping the law, shape up the law rather. Okay, so those are certain aspects which are also very important, because when we say deepfake technology, it's not only to do with cybercrime, it's also to do with how IPR is being shaped, whether a copyright infringement occurs or trademark. We just saw in those cases, or passing off, or a publicity right or personality right, or looking at cybercrime, but also ownership and declaration. Again, linked issue is the moral rights. Supposing if somebody has created a very original piece of art or a literary work, and that gets modified by somebody else without consent, obviously it will be an infringement of one's IP rights. And in that space, if you look at that, then obviously it will be something that affects the commercial gains one can make out of it. So that's an important aspect of ownership and declaration, and also moral rights. Somebody whose work should not be tampered, should have an sanctity of work as well. So those are also important aspects to be looked into. Now, coming to the other international, I would say, initiatives in this area of law, we have the Code of Practice on Disinformation in the EU. Now again, this is to combat disinformation spread through use of deepfake technology. In US, we have the Deepfakes Accountability Bill, which is of 2023. This again protects national security. So any deepfake technology used with the intention of threatening national security will have to be dealt with under that. Deepfake Task Force Act is also being discussed there and in the US. And we have California Privacy Act of 2018. So these are some initiatives, and in China, again, regulation on deep synthesis is been discussed. How the comprehensive regulation on deep fakes is being implemented, to curb the disinformation and fake news again. So these are certain things, but then in the industry segment as well, the Bletchley Declaration has been given by 29 countries. 29 countries, and India is also a signatory there. So we have all participated to look at how we can prevent severe harm which is deliberate, or even in case of unintentional, which arises from the increased use of AI technology. So these are certain initiatives, and Virginia became the first state in the US to impose criminal penalties on the distribution of non-consensual deepfake pornography. Then Texas also has become the first state in the nation to prohibit creation and distribution of deepfake videos. So those are certain initiatives in various parts of the world and some states of the US as well. Then comes to, if we come to see the publicity right as such, we have just discussed two important cases, but there was also a Gautam Gambhir versus DAP case. If you would have seen this in the press. Gautam Gambhir is a famous cricketer, and using his name, the some chain of restaurants were misusing the name. That was the allegation in the case, and it was found later on that although the name was being used by the restaurant chain, the commercial gain out of it was not being made. So therefore, it was held that in that scenario, since there is no commercial gain, there was no consequence of this infringement, and like it was held to be not really an infringement in that sense. However, there have been certain cases like the Titan case I mentioned, where a lot of commercial gain and profits are being made out of not only just copying or morphing the image of people, celebrities, but publicly a lot of commercial gain is also being sought. In such a scenario, obviously damages, injunction, those will flow. Now, so therefore, in such a scenario of publicity and personality right infringement, commonly we see copyright, trademark, right to privacy, publicity rights, all intermingle, and they lead to the final relief that is being given. And if it's a copyright act, then obviously we look at criminal or civil, look at that aspect as well. And based on that, one decides, which remedy we want to pursue. There have been many other cases, although I would not mention too many, but yes, for example, in Lanham Act, we have one section of 43A1A, that is regarding non-consensual use of persona. This is an act which is, again, banning the deepfake technology, using this deepfake technology for such purposes. And this origination of this personality right, in specific, this right, infringement came from the Halen Lab versus Tops Chewing Gum case. It's a very famous foreign case, which was being, discussed in one or two other cases we looked into. But essentially, what we see in India, it comes from our common law right, and also it comes from our right to privacy, which is fundamental to our Indian constitution. We look at the Indian context of the same. In cases of drawings, even morphing of drawings has happened, and in such a scenario, there have been again cases of Hilton versus Hallmark cards, for instance. There, again, it was held that even drawings, it's not just about persons or people, but even visual creations, those can also be a subject of original work. And if they are original, then they cannot be tampered with, and the moral rights of the author will also be affected. Not only that, you may seek to gain commercially from the same, and they need to be protected. So whether it's in India or abroad, the same principles of law actually weave this whole theory of law of privacy and personality rights, and how deepfakes can be interpreted in this light. So I saw a lot of commonality when we were looking at foreign judgments or Indian judgments. I saw a lot of commonality in the principles which apply, and by and large they were on the same length, which were replicated. One very important aspect which we need to bring into attention is the fact checks. In the news, when we see circulation of content out, there's so many news channels and newspapers which actually have fact-checking, websites and features. So instead of mindlessly forwarding on social media, it's our own responsibility also to do a fact check. And these days, the social media have started flagging if it's a suspicious content. So that's a good thing, that they are also taking industry steps to curb the replication of content, especially if it is not something credible or suspicious. So that is also becoming a tool for us to prevent the spread of this cybercrime. So in the end, I just want to say that deepfakes as a technology can be both a boon or a bane. It's up to us how we use the technology. We have to accept the technology changes which are coming today. However, we have to do it with a proactive approach to regulate where it is necessary, and let it be, let it flow in the nature of inventive spirit where it should be. So unnecessary regulation is obviously not welcome, but at the same time, leaving the horse wild without any reins is also a very dangerous thing. So we need to curb where it's necessary. So both prevention and combating are essential to make the best use of what we have in terms of technology and AI, especially generative AI. And it cannot flourish, whether it's India or abroad, unless and until we have some responsible use of AI and deepfake technology. In the end, I just want to emphasize that if we use responsibly this technology, it can be a big, I would say, it can lead to a big leapfrog for not just India but for the rest of the world. That's all.
Thank you, Karnika. So nice of you, always nice. Once again, you made it crystal clear of it's a very prominent and important topic which we are discussing. I think further transfer. Before question answer, I request Akanksha will say a vote of thanks. After that,
On behalf of the Friday group now, we thank you very much for this wonderful session. I hope everyone, all of us, have learned a lot from this lesson and from this lecture on AI and deepfake, ma'am. Thank you very much, ma'am.
My pleasure.
now we'll go for question answer. You know that? No, Panjwani sir. Panjwani sir. No, Panjwani sir.
We are facing day-to-day problem on our mobile. The bank said be careful. You also said be careful. How to be careful? There are so many messages coming. All types of messages. Bills are coming. And banks usually say, I don't know what they say, but they want money. That your bank balance has become below 10,000 or 5,000. Such messages come. So when I go physically, because nobody picks up phones in India.
Nobody.
Bank wala will never pick up a phone. So I go personally to UCO Bank. Did you send this? No. How to avoid it? They say you avoid it. How do I avoid it? It's coming UCO Bank.
So the best way.
So then I'll tell you. This is UCO Bank. Then IGL bills, pending bills. In the end, comma, if paid, ignore. But day after day, this bill is coming. And I keep asking this supplementary manager of the society, what others are doing. They say they also come here. I give them a photocopy from the computer free of cost so that they can check if they are paid or not. Because we are paying through mobile now, computer or mobile. So anyway, twice now he has given me, but now he says that this cannot go on like this. You make your own arrangements for downloading the bills. I have now introduced you, now you download on your own. So all these things require learning.
Absolutely.
So they all come into this, whatever your lecture is today.
Yes.
It comes within that.
So
We are
cybercrime
looking
especially,
like fools actually.
what you are talking about is phishing attacks. We are actually very susceptible to phishing attacks because people are getting on their mobiles the email, SMS or a voice message, even phone calls, which are pretending to be from a general banker, but it's not. So the best way to deal with these cases is that if you have a relationship manager, for example, store his number on your phone so that you are not fooled that somebody is calling from a next bank, and only talk to that relationship manager. When it is downloading, you don't download those content which you feel are coming from an unknown number or an unknown email ID, for instance. So that's the best way, sir. And then we have a two-step verification, which is the RBI norm also. So for every payment to go through, there has to be an alert sent on the registered mobile, on the SMS or the email ID of the person. And there is a two-step verification which happens. So if you have to make a payment using even your credit card, for instance, or even if you are doing a UPI transaction, there has to be an OTP which will need to be put in. So unless that happens, the transaction will not go through. So those are certain measures which RBI has also come out with, and as a user we need to be sure of attaching only those bank accounts to our payment wallets which have a very low balance. I personally don't do that because I don't like the high risk email accounts to be attached to the general payment wallets that we use. So I purposely use the low budget, like the low quantity ones, which are just not much risk involved. So there you just have a minimum balance in that account and only use that account so that the others are not exposed. That's the best.
Confined to topic, I mean, deepfakes and all, so that.
Ma'am, in copyright law, we have this dichotomy of idea and expression. That okay, if you can get some idea from any author or an artist, and then you can express it in your own
Yes.
words or in your own ways. So, if we talk about deepfakes, so if it is not deceptively similar or not derogatory, and someone comes up with the help of technology, a new thing with an original picture of someone else's. So would it fall under
So if it's an original picture of someone
infringement
else,
of passing
there
of-
has to be a consent first of all. You can't click somebody's picture. You should not even take somebody's picture and misuse or use it without permission. That is something, unless it's a public record, that some content which is a part of public record. Now it really depends. If it's a right of privacy, for example, if it's a family pic of someone, it is again a right of privacy. How that is used anywhere else, and therefore it's protected by privacy. So what you are saying is a different scenario.
For
It's not
artists,
really breach
yeah.
of privacy. It's maybe some
Artist.
work of the artist, and you're taking that work. Then it has to be the raw material behind it, not the main work as such. Because when we talk about software, for instance, you have open source. It's a different technology again altogether phenomena. There you can build on and create better product or software. But if it's somebody's own proprietary software, like a closed software or a owned work, then to make an alteration to that is again not possible under copyright law without permission. So
So
that
there
is
would be no room for us to save our clients. There would not there be any gray area.
there isn't any. If you're talking about a photograph, for instance.
Yeah, with the help of some references or you mentioned something hologram related thing.
If it's a watermarked thing, then yes, you are declaring that you have done so. The main point is whether it is what is the purpose for its use also. And if you have just created to show that this was created by using the work of, for example, we have seen the Beatles group. There was again a controversy using deepfakes. The voice of one of the singers, John Lennon, was replicated, and that was held to be AI based. So whether the ethical considerations flow from that work, whether the moral rights of that author are breached because it's his personality right. He may not be anymore in this world, but his work was his work, his personality was his personality. So if there is an ownership right which is infringed, maybe a gramophone record company had at that point of time. So they could also come in legal action, So it really depends. What is the motive behind it is also an important factor.
Amit Pratap
I
sir.
have one question. How can Indian government can tackle the issue of misuse of AI?
Misuse of AI. We have already deliberated at length at the ministry level, and while the formation of the DIA, the Digital India Act, we've had roundtables with the minister, and we've talked about extensively on the high-risk systems should be regulated, and I emphatically even today say that India needs to have a separate AI law. And because I'm very passionate about the area, I also created a proposed AI framework, which I have discussed. So that's important because a proposed AI law for India in itself, like a separate law, will be the key to the solution. Because otherwise, this problem will remain. Having just one or two sections in the new act, like the DIA Act, may not be enough. Because only high-risk systems will be regulated, whereas even the medium and the low-risk systems need some regulation or some guideline how we need to proceed. So that's important.
Please.
Ma'am, my question is that do you think we need a overhauling of all the laws, like of the IPC and the intellectual property right? because recently in USA kidnapping happened, and this kidnapping was unique because there were no kidnappers involved. The kid was voluntarily made to isolate himself, and his all accounts were hacked, and his parents in China were forced to pay the ransom money. So it was a completely different sort of the kidnapping that came into the front of the public for the first time, and there was no answer to the law for the old books to how to deal with this case. Secondly, ma'am, we talked about the blockchain technology, and we say that the blockchain technology is a very transparent industry, transparent way to work in. Recently, ma'am, one blockchain was being used in which out of 10 blocks, 6 blocks were altered, and it overturned the whole ledger of the accounts in the favor of the company that was doing the fraud. It was an experimental project that was done in Google, ma'am. So, ma'am, now it makes the perception of justice or truth to be very subjective to mathematical equations. So my question is, do you feel now we need an interlinking of all the laws that are available in the country with a mother law, so that we are able to counter all such problems? Because
I know there is this area of cyber law itself is a converging law, because what we are realizing now is increasingly, fraud can be circumvented. For example, there was once a ban on particular SMSs going out of a particular phone. Not more than 200 were allowed, because that time there were some riots or something. So the TRAI had come up with that regulation, and what happened in that scenario was when the TRAI came up with this rule, easily the cyberspace was being used to make phone calls or messages through VoIP, through voice over internet protocol. So if that is happening, you can easily circumvent the law. So increasingly, I think it's important to harmonize the law, and cyber law in itself is an amalgamation of many laws as a special law, but it touches on a lot of other areas. Like I said, IP also gets infused in it, and we also have the criminal law coming in, and apart from that, the other aspects also get roped in. So it's something that is converging the law in any case. Evidence has changed. We have the section 65B of the Indian Evidence Act, which deals with the electronic evidence, for instance. So it has ramifications, it has ripples all across the other laws as well. It's not that only that space will be altered, or that legislation alone is a standalone. It has key provisions, but it does have implications of law in other aspects of law as well.
Any questions you want, please?
Metaverse, Facebook is trying for metaverse. In that, people are going totally virtual reality field, and people, what are the rules going to be gone in for that metaverse? People will be interacting with all kind of commercial activities and social activities. So how they are going to regulate that environment? And in London, I think a minor girl virtually raped.
Yes.
So how such IPC going to?
Yeah, our conventional principles of law, we are actually examining it. That in metaverse, for example, where it's not just only gaming or entertainment, it's also offices functioning on metaverse. A lot of IP assets are also involved, because there are shows which are concerts happening on the web, or conferences for that matter. So definitely, when it comes to criminal law, we're examining that human element is essential. Otherwise, how you define a rape, or how you define a particular harassment or a extortion racket, the whole scope of the purview of the law, that section changes. If it extends to cyberspace, what you claim in the offline space as a harassment or outreaching modesty for women, for instance, has a different connotation altogether. If it's an avatar of that person online, which is being defamed, or a deepfake of the avatar is created, does the actual person who is playing the game, for instance, is also affected, or can say that I am being harassed? So these issues are new. Like he was explaining that deepfake could have been used for a kidnapping attack. These areas are completely new, and sometimes you don't have exact provisions citing this terminology there, but some essential ingredients would be pulled in to understand that this could apply in such a scenario. That's what we've been doing today. So the conventional concepts are changing in the metaverse and AI times. So while till the time we have clear-cut provisions on the same, we will continue to use our existing law and stretch our interpretation in that light. We will at some point need specific laws. We never had, for example, in our IT Act, a provision on, say, cyber child pornography or cyber terrorism. All these were added. We never even had this term, wireless, for example, earlier. So in 2009-10, when amendments came, these terms were introduced, or these provisions were introduced for the first time. So that's how the law involves with technology, and that's what we are doing.
Want any question, madam? Any? Yeah, please. 1 second. One second. She's asking.
I wanted to ask in a single matter if spoofing, spare phishing, catfishing, everything is involved and the source is not known.
Yes.
You know, sometimes like recently I faced this myself in my family, that Patanjali wala site for the Yogram.
Yes.
So and it's a daily, I think they were saying it's 60 to 70,000 rupees scam daily it is happening, and for 5 years this has been happening. And Ramdevji also knows this. They have made a duplicate site, some hackers, and it's not one group, they're like various groups. They have put up a link out there, it's exactly the similar one, and there's a phone number, and you call up. Even if you call up on their same number, a hacker will answer you from some other place, and he will say, okay, fine, you for registration.
These are all phishing scams.
Have phishing scams, and this,
one needs to report them and take action.
we did it, but then they said some gang is operating from Bihar. We cannot do anything about it, and then the location got changed, and we got nothing happened.
Now she's asking legal opinion.
So we have to avail our criminal remedies. We have to report it to the police. They have to crack the scam, how this is happening, and punish the offenders basically. But you need to report this on that cybercrime
But
portal.
ma'am, now because of the AI thing coming up and deepfake, now people are making their avatars, and then on YouTube. Suppose now, if I say something for someone XYZ, then I will be faced for defamation. That she's making defamatory comments about me. But then what about the avatar that has been made, and that I have only made it from, suppose मैंने UK से somewhere I've taken my I've done my login and I've made a site from there. The source is not known, and I can also do the same thing.
I need to track the place from where a website is created. For example, I'll just tell you one of the cases I dealt with. If you see online also, in the Delhi High Court, I dealt with one case where a celebrity, a spiritual guru was being defamed online.
Yes.
And it's in that case, it's called Nirmaljit Singh Narula versus Hub Pages. We got an interim order from the Delhi High Court restraining the website from publishing any defamatory posts about this spiritual guru. And in one of the other cases, it was a phishing website. So those were asked to be taken down.
The source was known.
The source, we could know the source even through whois.net. If you type in Google, for example, search for whois.net, and you type the name of the website, you will get to know the owner of the website, the address, the contact
This
details.
is what I wanted to know.
You please try that. That's a very interesting tool. Also, you can find out from what is my IP. That is another website which tells you the IP of a particular person or a particular area. Like if you're getting an IP address, where it is located, from which place, and what you will get is a public IP. If you know any email has a header. So if you go to full source, you will get a header, and in that header you will get a originating IP. That is a public IP. For example, if it is Airtel, I go to Airtel and I find out from Airtel from where is this mail sent. It will tell me exactly from where it was sent because they have the private IP. They don't reveal the private IP. In the IP address in the mail, the header will have the public IP. From the public IP, I will know the broadband company. From broadband company, I will come to know who is the owner of that.
And sometimes, suppose the main person, the main culprit is not the owner and somebody else
Yes.
taken it on like some.
It could also be privacy protected, but then those are services which these companies charge. But if there are court orders, then they have to reveal who is the subscriber of that email. Okay.
But
So this is all what we do. This is all cybercrime law.
Yeah, thank
This
you.
is all
Thank
what
you.
we do.
Last question, please.
My
question is like this news comes into today of deepfakes.
Yes.
It's like there are incidents that has occurred in India also lately. You get a call from WhatsApp, and as soon as you pick it up, you got captured.
Yes, yes.
So they seek extortion of money from us.
Absolutely. What you are citing is a very clear example of deepfake, misuse of deepfake technology.
My ultimate question is, what is the quickest remedy that one can opt to prevent all these?
So, number one, you don't pick up calls from unknown people or strangers. There are multiple times when even senior citizens have been duped like this. I have handled multiple complaints and lodged those complaints with the police on behalf of the clients, where senior citizens even have got these calls, and they are all rackets which are operating. So don't pick up any calls which you feel are suspicious, even on WhatsApp, especially video calling. If somebody is trying to video call you and you don't know the person, please, my advice is don't pick up those calls, because they are bound to be all for illegal purposes. This is happening as a very rampant, scam. So that's the advice.
There's a girl in the front, she's not very
And lodge a police complaint the moment something like this happens, if at all it happens, so that you're at least informed the right authorities.
There is the Data Protection Act that is coming.
DPDP Act is there. We have the DPDP Act, but then that's a different scenario. We're talking about deepfakes right now.
Like, Data Protection Act has come into play. Still, if you register on, if you have your contact only register with somebody, those numbers got out. You got all those fake news, all those fake informations. Not only that, in order to counter those fake messages, you got number from Israel, you got a number from Afghanistan
So
texting
DPDP
you
Act will
saying,
definitely protect you better. I mean, in terms of India, we see DPDP Act requires the service provider, whoever is taking your information, whether it's a phone number or it's an email ID, to actually disclose what he's going to do with that particular number and how it is going to be shared, if at all, and for what purposes. So that will actually put the obligation in a very strict manner on the service providers. They cannot misuse the data. And if you choose to withdraw your consent, for example, if you've made inquiries to buy a property in a particular area, and afterwards you are not interested in the services anymore, you can actually choose to withdraw your consent and say, you don't use my numbers anymore, nor pass it on anywhere, and delete it from your systems. That right is there in the DPDP, which I think will strengthen the Indian data protection law.
Yeah. Take your autograph.
Surely.
Next, extended in the canteen.
Surely.
Yeah.
Thank you so much.
Here is the signature. Message.
All right.
Here.